Good morning, everyone. I'm Riley King, and welcome to my morning news report right here on the Riley King Network. Let's begin. Federal judge rules New Hampshire absentee ballot verification law unconstitutional. A federal judge Tuesday ruled unconstitutional a New Hampshire law giving local election moderators the authority to invalidate absentee ballots by visually comparing the signature on each ballot with the signature on each accompanying affidavit. U.S. District Court Judge Lyndon McCrafty, in a 49-page ruling, found that the signature match requirement has disfranchised hundreds of absentee voters. The judge noted that a person's signature may vary for a variety of reasons, including age, physical and mental condition, disability, medication, stress, accidents, and inherent differences in a person's neuromuscular condition and stance. Variations are more prevalent in people who are elderly, disabled, or who speaks English as a second language. The American Civil Liberties Union challenged the 1979 law on the bias that the signature match requirement provides no resource for voters whose absentee ballots are rejected based on the appearance of their signatures to prove they are legitimate voters. The ACLU said its 3 clients in the case were not notified that their signatures were invalidated until the ACLU itself contacted them several months after the 2016 election. He said that while the law has been in effect for 39 years, the Secretary of State said that the system has been in use in varying forms since the 1920s. The judge said signature match law violates the 14th Amendment, which guarantees a right to due process and forbids states from reconstructing citizen rights under the U.S. Constitution. She permanently enjoyed the state from enforcing the law, which means it cannot be used in the September 11th primary or bearing a quick fix the November 6th general election. Associate New Hampshire Attorney General Anna Edwards said her office had no immediate comments on the ruling. The 3 plaintiffs in the case were Mary of Manchester, who, according to the suit, is 95 years of age and blind; Maureen of Derry, a 20-year military veteran; and Thomas of New Hampton, a professor. According to the ACLU's suit filed in March, election officials in the 3 communities refused to count their vote because they decided that the signature on their absentee ballot affidavit envelopes did not match the signature on their absentee ballot applications. The ACLU wrote that the officials never told plaintiffs that they rejected their ballots, nor does New Hampshire law provide an opportunity for plaintiffs to show their ballots are valid and should be counted. The ACLU said that by the time it informed the plaintiffs their ballot had been rejected, nothing could be done. The group said Tuesday during the 2016, 2014, and 2012 elections collectively, this law defranchised nearly 800 voters. McCrafty rejected the state's argument that the Secretary of State office provided adequate training for local election officials, that ballot rejections are not widespread, and that overall the process is constitutional. She also noted that moderators receiving no training in handwriting, analysis, or signature comparison, no statute, regulation, or guidance from the state provides functional standards to distinguish the nature variations of one writer from another. That suggests two different writers, and the moderator's assessment is final without any review or appeal. Hardy said she has never missed an election in her lifetime, and as a self-proclaimed rule follower, she knew she needed to get her hands on an absentee ballot when her job took her out of town. Hardy said that had she known about that law that allowed for her ballot to be thrown out, she would have taken extra time to be sure her signature matched. And that does it for my morning news report right here on the Riley King Network. I hope you all have a great rest of your day, and I'll see you back here later on today for another news report. Goodbye, everyone.